This explainer examines when reasoning hurts legal drafting, the verbalization bottleneck and patent claim generation by Lekang Jiang, Wenjun and Stephan Goetz. The purpose of this explainer is academic research and educational study.
All right, let's jump right in. Today's agenda covers 6 parts: the core research question, key concepts and context, the methodology and experimental setup, our findings on implicit versus explicit reasoning, the verbalization bottleneck itself, and finally, conclusions and key takeaways.
Section 1. The core research question, investigating COT in legal drafting.
Let's map out the logic on our virtual chalkboard here. So, first up, the problem. Look, manual patent claim drafting is just incredibly difficult. You're taking a highly complex technical invention, which usually spans over 1,000 words of dense description, and you're trying to distill the whole shebang into a strict, legally binding, hierarchically structured claim. Honestly, even for human experts, it's exhausting. For an AI, it's a massive challenge. This leads us right to our core research question. Can we use a popular AI technique called chain of thought, or COT, to actually help large language models generate better legal claims? And to figure that out, the authors proposed a really clever investigation, testing implicit versus explicit reasoning.
Section 2. Key concepts and context.
Before we go further, we really need to nail down our terms. The core concept here is chain of thought prompting. In plain language, this is just when you tell an AI to kind of take a breath and think step by step before spitting out an answer. Historically, this has been an absolute game changer for AI. If you're doing math or logic puzzles, having the model break the problem down into intermediate steps drastically improves its accuracy. It's exactly like asking a student to show their work on a math test rather than just guessing the final number.
Now, here is the crucial distinction the authors manipulate in this study. We essentially have 2 flavors of this technique. First, there's implicit COT. This is where the model is instructed to think step by step, but it does so entirely internally. We only ever see the final generated patent claim. On the flip side, we have explicit COT. This is when the model is forced to actually write out those intermediate reasoning steps as visible text prior to generating that final claim. Keep this distinction in mind, guys, because it's literally the central variable that unlocks this paper's entire mystery.
Moving on to Section 3, methodology and experimental setup. Take a look at this diagram pulled straight from the paper. It maps out the 3 approaches beautifully. Up at the top, you have your initial input, the raw patent description. Then, over on the far left, you've got the plain prompt, which is just asking the AI to write the claims directly, no extra instructions. But shifting over to the center and the right, you see the chain of thought prompt branching off into our 2 variants. Implicit, where the AI outputs patent claims only, and explicit, where it outputs thinking and patent claims. Simple enough, right?
But you might be wondering, what exactly is the AI thinking about? Well, the authors didn't just throw a generic think step-by-step prompt at it. They actually built a highly specific 3-stage zero-shot framework to simulate a professional patent attorney's brain. Step 1 is feature extraction. This is scanning the document to pinpoint the key technical features. Step 2 is logical grouping, so figuring out how those features depend on each other hierarchically. And step 3 is language formalization, which means translating all those organized concepts into strict formal patent legalese.
All right, Section 4, findings, implicit versus explicit.
Okay, let's look at the human expert evaluation scores. Check out that middle row. GPT-4o, when using implicit chain of thought, scores a 92.7 average. That is a massive 5.2-point jump over the plain prompt. The logic score alone jumped nearly 6 points, so planning definitely works, but now look at the bottom row. Explicit COT. When the model was forced to write its thinking out loud, the average score dropped back down to 90.5. Across every single metric we're looking at here, content, logic, and language, explicit reasoning actually degraded the output compared to implicit reasoning.
So what does this all mean? Well, the data demonstrates a deeply counterintuitive finding. In almost every other domain of AI research, forcing a model to show its work explicitly makes the final answer better. It's standard practice. But here, in the highly structured, detail-obsessed world of legal patent drafting, forcing the AI to externalize its reasoning actually hurts the final product. No way, right? The immediate question for us as academics is, well, why?
Which brings us to Section 5, the verbalization bottleneck.
To answer that why, the authors identified 3 distinct mechanisms of failure that happen when an AI is forced to verbalize its legal reasoning. Mechanism 1, abstraction of critical detail. Mechanism 2, disruption of internalized generation patterns. And Mechanism 3, error cascade across reasoning steps. We're going to break each of these down logically.
But first, I want to share this quote directly from the paper because it perfectly captures the underlying physics of the problem. Quote, "The model's rich internal representations are compressed into a sequential, lossy verbal summary, and all subsequent generations are conditioned on this degraded intermediate." End quote. Think about it. When the AI thinks internally, it's holding this massive, multidimensional web of data in its digital brain. But when you force it to write that thought process out as plain English text, you're essentially forcing it through a funnel. It becomes a lossy summary. It's kind of like taking a high-definition 4K photograph and compressing it into a blurry, low-res JPEG. Once it's compressed into text on the screen, the AI has to rely on that blurry text to write the final legal claim, completely losing touch with the original high-def source document.
And this brilliantly illustrates mechanism 1, abstraction. The authors provide this really concrete case study involving a patent for an intraocular lens package. Now, when thinking implicitly, the AI perfectly retained highly specific structural elements from the source text. I'm talking words like tray, bottom walls, and blind holes. Those granular details are absolutely crucial for legal protection. But when it was forced to write its reasoning explicitly, the AI just summarized. It abstracted those specific terms into a generic, overarching phrase, water reservoir systems. In a math problem, abstraction is great. But in a legal contract, abstraction literally destroys your legal protection. Now let's move to the error cascade, which is mechanism 3. The authors ran a diagnostic check on the explicit code text, going stage by stage. In step 1, when the model was writing out the extracted features, it only hit about 62 to 72% precision. Think about what that means. It was immediately dropping up to 38% of the critical details. And because the model now has to rely on this flawed written-out list for steps 2 and 3, those errors compound. Once a specific detail, like our blind holes example, is dropped in the text of step 1, it is irrecoverably lost forever. It's gone.
So let's reconstruct this complete chain of reasoning together on the chalkboard. We start with a rich, detailed source document. By asking the AI to write out its plan, we force an explicit verbalization. That verbalization acts as lossy compression, basically throwing away legal specifics. This text then acts as an interrupted internal pattern. That was mechanism 2, by the way, which disturbs the AI's natural ability to map the source text directly to a structured legal format. And ultimately, this whole sequence leads straight to a flawed claim output. The reasoning itself didn't help. The verbalization of that reasoning is what created the bottleneck.
All right, wrapping things up with section 6, conclusions and key takeaways. So, what's the big picture here? The main contribution of this research to the fields of NLP and legal tech is proving that reasoning externalization is not a universal good. In highly structured, detail-preserving tasks, where getting the exact phrasing right is literally the whole point, forcing an AI to externalize its thoughts actually creates a destructive information bottleneck.
Now, as with any rigorous academic work, we definitely need to acknowledge the limitations. The authors make a point of noting that this study focused purely on zero-shot prompting. That means the AI was given instructions without any prior examples to learn from. So how this verbalization bottleneck interacts with things like few-shot prompting, fine-tuning, or more complex agentic workflows, well, that remains untested. The bottleneck is a heavily supported, highly testable hypothesis, but it's not yet an absolute law for all AI systems everywhere. If you're taking notes, here are the 3 concise lessons you absolutely must remember from this explainer. Number 1, chain of thought frameworks generally do improve complex patent claim drafting by giving the model a necessary logical structure. Number 2, however, implicit COT, basically letting the model plan silently, consistently outperforms explicit COT. And number 3, explicit reasoning degrades legal outputs because it forces the model into an abstract, lossy compression of details that are legally vital. I want to leave you today by pointing toward future research. If writing out a plan destroys the granular detail necessary for patent claims, what on earth does this mean for other detail-preserving tasks? What about AI contract generation, or regulatory compliance filings, or even statutory text generation? As we integrate AI deeper and deeper into the legal field, we really have to recognize that making an AI's reasoning transparent might actually come at the direct cost of its drafting fidelity. It's a fascinating trade-off for sure, and one that requires a lot more investigation. Thanks for joining me for this breakdown, and keep questioning how these models actually think.